Many thanks for staying tuned. It's still the conversation here on Lagos Television, and on this segment of the program today, we'll be taking a look at the Ecowas Court of Justice, and our guests this morning will be sensitizing us all, including you, the viewers, on what exactly the Ecowas Court of Justice does. And I'm sure that we all remember that this year, 2025, the Ecowas is celebrating its 50th anniversary, and I'm sure what we would also learn today would give us more insight into what this court does and how we all can partake of what they do. And so we have here the Chief Registrar of the Ecowas Court, Dr. Yauza Uro-Sama. Thank you for being on the program today. I hope I got it correctly.
Yeah,
okay,
correct.
Awesome. Okay, just to be sure. Right, so let's take a look at the Ecowas Court of Justice. What exactly is this court all about?
The Ecowas Court of Justice is, good morning everybody, good morning to the viewers.
Thank you, sir.
The Ecowas Court of Justice is the principal legal arm of the Ecowas as a community. You know, the Ecowas is made of many institutions. You have the Commission, which is the executive arm of the community. You have the Parliament, which is the legislative one. And you have other institutions, including the Ecowas Court of Justice, which is the judicial institution of the community.
Okay.
And it has a number of missions, and I believe that in the course of our discussion,
you would definitely tell us some of that. You can as well just go ahead and tell us, because again, if we know that it is the judicial arm of the ECOWAS community, so what are some of the cases that the court is mandated to handle?
The court, through its protocol of 1991, had initially a mandate of interpretation of the community legal text, interpretation and application of the community text, but also giving advisory opinion on whatever either the member states or the head of institution request for. But the 1991 protocol has been amended by the one of January 2005, which expanded the mandate of the court. So beside the two core mandates that the court was entertaining, it has now the competence on human rights violations, on the preliminary rules, what we call also referral. For example, if at the national court a judge received a case and wanted to pronounce a judgment, once the community text, the legal text is invoked by any party, the national court has to stay action and request for the interpretation from the Ecowas Court of Justice before pronouncing its judgment. Beside that, disputes among member states can also be handled by the Ecowas Court of Justice, as well as the public service dispute, when a staff of any institution has an issue or dispute with the institutions. So after exhausting all the internal procedure, then it can also come before the Ecowas Court of Justice for redress. There are a number of competencies that the court handle, but more or less those are most of the competencies that the court has been entertaining so far since its inception.
Okay, let's talk about the rule of law and access to justice. We all know that is a major problem on the continent of Africa. So what is the ECOWAS Court of Justice doing to ensure that citizens of ECOWAS have access to justice, and of course speedy one at that?
Okay, first of all, the protocol of 1991 that I was referring to earlier give competence, jurisdiction to the court to handle any interpretation issues, any application of the community text. And the one of 2005, which is an expanding protocol, come and expands the area of jurisdiction of the court. And regarding the violation of human rights, for example, the protocol has recognized to individuals the possibility to come before the court and seek for redress whenever they have their human rights violated. Before 2005, that did not exist. Is from 2005 that individuals are also entitled to come to the court for violation of their human rights. Besides that, the premises of the court at Abuja, the premises are open to any citizen who either want to seek for information or want to lodge an applications, either citizen, lawyers, and agents. They can come to the court and do whatever they do. And adding to that, there is also an innovative process that the court started, which is the electronic case management system, where citizens can at any time from anywhere, even including their offices, wherever, lodge applications virtually before the court, attend to the hearing of the proceeding before the court from their offices virtually, and also receive judgment virtually. So from A to Z, citizens can stay in their office or even in their houses and be interacting with the court from the lodgement of the application to the reception of the judgment.
Free of charge?
Free of charge.
Oh, free?
Free.
Wow.
Free of charge.
I like that you
completely free of charge.
Completely free of charge.
Because I was going to ask you, what are the procedures for an individual, to have access to this court?
Yes.
And you said something that if a case has been held at the national court, it can also be brought to
the ECOWAS.
Yeah, on some conditions.
On some conditions. So I'd like you to expatiate on that.
Yes, the court has several times declared that it is not an appellate court of the national court. The court is complementary to the national court, and once a case is pending before a national court, there are conditions for the Ecowas Court of Justice to intervening in this kind of matter. First of all, before your application will be admissible before the Ecowas Court of Justice, it has to not be anonymous. So you have to give your name, your address, and everything, all means of identification
right.
That can really identify you as a person. That is one. Secondly, the case should not be pending before any international courts. So those are the two conditions that the protocol of 2005 provided for. And then there is a jurisprudential condition which has to do with the fact that you have to be a victim of the violation of human rights. So if the three conditions are met, then you are admissible to come before the Court of Justice. Now, your question is, if a matter is pending before a national court, can the Court of Justice, Ecowas Court of Justice, address the case? The question is, in principle, no, because the condition that is required there is your matter should not be pending before any international court. National courts not being international court, so the court can still entertain your matter. But like I earlier said, the court is not an appellate court of the national courts. So, but before the court will handle these kind of issues, you have to prove that you have not enjoyed a fair hearing at the national court, or the proceeding were not in compliance with the international instrument on human rights. So those are conditions on which the court can entertain your matter, even though it is pending
before a national court.
Before a national court.
Okay, so at the moment you are in Lagos for a sensitization. So what is the sensitization all about, and why did you decide to choose Lagos?
As you may know, the protocol of 1991, especially Article 26, paragraph 2, said that the court has its headquarters in Abuja, and that is where it sits and pronounces its judgment. However, in order to bring the court closer to the citizens, the court may, under certain circumstances, move to any member states to have court sessions, hear parties, and pronounce judgment. Coming to Lagos is not the first time the court goes outside its headquarters. The court did it. The court was in Accra, it was in Bamako, in Mali, it was in Ouagadougou in Burkina Faso, it was in Abidjan in Côte d'Ivoire. It was also in Ibadan in Nigeria some years back. So within that framework, the court decided to come to Lagos, also because Lagos is, in terms of size, a very, very big state, and we think that the audience will be larger in terms of getting more stakeholders and also the citizens of the community to be informed about the court, its existence, and also raise all the stakeholders' knowledge about the court, its mandate, and how to file cases before the court, and why the court is coming at the grassroots of the community citizens in order to be closer to them and to let them know that it's not difficult to
actually file your case.
It's not an elite
court. It's for everybody.
It's for everybody, even for the indigent. And in fact, when it comes to our prominent mandate, which has to do with the redress for violation of human rights, we believe that indigent population are even more, important in this area than any elite personality. However, even some head of state former head of state have been coming to the court to seek redress. Yes, of course. So we have, I can cite President Yayi from Benin Republic, for example. President Tanja Mamadou from Niger. For example, President Hissène Habré from Chad. Even though Chad is not an ECOWAS member state, but because he was residing in Senegal, so he lodged an application before the court to get his right recognized.
But do you need a lawyer to help you file your case?
It's compulsory. You need a lawyer or an agent.
Or an agent.
Yes, you need a lawyer because in order to ensure that the legal technicality
the terms, the correct terms.
So it's compulsory to be represented either by a lawyer or an agent. Yes.
Okay. So, I'm sorry, Joy. So for those Lagosians whose rights might have been violated at one point or the other, this is an opportunity for them to seek redress in the Ecowas Court of Justice. And two, over the years, what has been the kind of feedback or success story of the Ecowas Court of Justice?
Oh, the Ecowas Court of Justice has done a lot. There is a plethora of judgment that the court pronounced in the past. I can give you maybe 3 or 4. The first one has to do with the case between Adija Toumani Kourao against the Republic of Niger, where the court pronounced or enjoined the Republic of Niger to abolish slavery laws in Niger, because before that there were slavery laws in Niger and slavery was still going on.
Okay.
But from that decision, the Niger abolished all their its slavery laws.
Okay.
I can give a second case which has to do with Amnesty International against Togolese Republic, where Amnesty lodged their case to recognize the violation of the right to internet of the citizens. So the court pronounced a judgment that saying that the right to internet is a derivative right to the right of freedom of expression. And it was recognized worldwide, and on that case, the court even received a prize from the Columbia Global Freedom of Expression of Columbia University in the US in 2022. I can also give another case which has to do with right to education. That is between SERAP and Federal Republic of Nigeria and UBEC, where the court recognized that right to education is a justiciable right, and everybody should enjoy it. And then maybe a last one, which has to do with the case between El Taib against Republic of Sierra Leone, where the court recalled to member states that they must ensure that they protect the human right of their citizen. Failure to do that does not give choice to the Ecowas Court of Justice than holding them answerable to wrongs, to the wrongs. So those are, I can go on and on because there are so many, but I believe that since our gathering here is limited in time, so let's just stop there. I can give
other examples.
There are like 30, 40, 50 cases where the pronunciation of the court really impacted seriously either in governance or in human rights violation.
Sorry, Joy, let me just quickly, just to build on what you've said here. Have you had instances where the rulings of the court were not adhered to strictly? Have you had any cases?
Yeah, we have. That's one of the challenges that the court has.
Okay.
It has to do with enforcement of
its rulings.
Of the rulings. As of today, the court has 21% of
compliance
rate of enforcement. Yes, and that is even one of the reasons why we are also in Lagos, because Nigeria is one of the member states who has a high number of
compliance with the rulings,
judgment that are not yet enforced, even though they are trying. They are trying to do
that. That obviously is not a good thing.
Yeah, of course. But I think we have started engaging them, and I believe that with time we will get the rate of enforcement increased, so as to increase also the credibility of the Ecowas Court of Justice. The court was established by member states, and we always urge member states to ensure that they enforce the rulings, the judgment of the court, so as to ensure that there is a credibility, they increase the credibility of the Ecowas Court of Justice. So we have a problem with enforcement, but there are a number of measures that have been taken to overcome this important challenge.
Are there other challenges that the court is facing?
Yes. Indeed, the major challenge has to do with enforcement. Why? Because there is a kind of limited political will of enforcing judgment, especially sometimes when they have a political sensitivity is not very easy to enforce. Indeed, the court also has other challenges, which has to do with the number of judges. Judges were 7, now they are 5, because there was a reduction of the number of judges in order to ensure that kind of rationalization of resources. You may recall that 3 member states left. Ecowas was made of 15 member states. Right. Now they are 12 because the Sahelian countries, Burkina Faso, Mali and Niger has left. So obviously there is a
gap.
A gap, limitation of resources, and then so we have so resources are one of the challenges that we also need to do. And another challenge has to do with limitation of awareness. Because as a court, you can't just take the floor and be talking anyhow. And we notice that there is a serious gap when it comes to awareness. That is why we are in Lagos here, because most of the community citizens don't know about the court.
Yeah.
Most of them think that is an elite court. Most of them, they don't know the mandates, the jurisdictions, and the practices of the court. So that is why we are coming closer to them to inform them about the court, to raise their awareness, increase their knowledge about the court and how to file cases, etc.
Right. So, since you've shared some of the notable cases, that the court has handled, and you did say that at the moment you're also leveraging on technology, meaning that from wherever you are, you can actually access the court. Is that the only way technology is helping, access to the court, or are there other ways that the court is leveraging on technology?
The court is leveraging on technology, like I said, on the electronic case management system, where from A to Z you can be interacting with the court, load your application virtually, attend a court session virtually, receiving your judgment virtually.
Okay.
And whenever you want to file either the initial application or further application, so you can also do it virtually. But beside that, we have other projects that we are handling. For example, we want to set up a legal aid mechanism where indigent populations, if they want to come to court, because they don't have means, they can also have a lawyer, and then a fund will pay for the lawyer to enable them also to be interacting with the court. We are also trying to put in place an arbitration tribunal where people, because they don't want to go through the contentious process, they can also come through arbitral tribunal. And that one also, if it is established, then it will be operating also virtually, as we are taking advantage of all the advantages that the technology is able to give us.
Okay, so aside from all these reforms and the strategy targeted towards ensuring that citizens of ECOWAS country have access to justice, what is the ECOWAS Court of Justice also doing to ensure that we have regional and, of course, continental peace in Africa?
As you know, ECOWAS Court of Justice is a court, and it is not an executive institution, it's not a political institution. It's render judgment. It's a judicial institution. It cannot go
beyond
that, go and be discussing with our member states on political issues or to engage or do advocate
Advocacy,
for political things. However, if the peace is disrupted, if the member state does not, if a member state does not comply with the protocol on democracy and good governance, or the one on prevention of conflict, so the court, if the court is seized, it can contribute in rendering decision, one, to maybe acknowledge the violation of the community text, two, and declare violation of any human right for any citizen, and then pronounce a judgment in order to contribute to bring peace wherever that peace is disrupted.
Okay. Joy?
In terms of engagement, what's the relationship like between the Ecowas Court of Justice and the Nigerian lawyers and judges over here?
Okay. The protocol described a bit how the relationship should be between the Ecowas Court of Justice and the national courts, the judges. And one of the sessions that we had on 7th of May last week is a judicial dialogue between the court and the High Court judges. And through that judicial dialogue, it was very clear that, one, the Ecowas Court of Justice is not in competition with any national court. Two, the Ecowas Court of Justice is complementary to national court. Three, there is a serious need for the Ecowas Court of Justice and the national courts to collaborate in order to ensure that is established a kind of community legal order, that is a kind of legal and judicial framework that will be put in place in order to increase or foster collaboration, and also in the interest of the population, so that whenever there is a case before a national court and the citizen brings the same case before the Ecowas Court of Justice, so that there will not be any friction, okay, any competition between the two types of the court. In a nutshell, is really a complementary role that the Ecowas Court of Justice has to play vis-à-vis the national court in order to ensure that there is a regional integrated legal and judicial system that will foster and enhance collaboration and partnership between the regional judges and the national judges, as well as with the lawyers. We have a framework where we work with lawyers of the region, and especially Nigerian lawyers, where from time to time they are invited in our international conference that we used to hold every year, where we discuss and exchange ideas on some legal topic that are prominent across the region.
Okay, so is there also any collaboration with the international courts?
Of course.
Like the ICC?
Of course.
Right.
We have collaboration with the African Court for Human Rights and People, for example, with the Inter-American Court, with UMUA, where from time to time we meet and engage in judicial dialogue to agree on some areas, to share experience, exchange on our respective jurisprudence, and come up with some recommendation that we follow up and ensure that they are implemented. So that also helps, for example, the African Court for Human Rights to, while in the pronunciation of their judgment, sometimes they quote Ecowas Court jurisprudence to support their own decision, and vice versa. The Ecowas Court also sometimes use the African Court jurisprudence to
also get their own cases. All right, before we allow you go this morning, you did also mention that three countries are at the moment out of the community leaving 12. So what role does the court play, or what role do you see the court playing in the future of regional integration and peace in West Africa?
The role of the court is to render judgment. That's the
bottom line.
And beside that, what the court can do is during its activities, extrajudicial activities like the international conference, like during sensitization or outreach programs, is to call for peace, to call for compliance with the community text, to call for enforcement of its judgment. The court has render a huge number of decisions since its inception, and I believe that leveraging on those judgments will clearly help to sustain peace, to ensure that we have a good governance across the region, and also comply with the relevant protocols that have to do with democracy and good governance, as well as the conflict prevention mechanisms.
Right. All right. Do you have any questions?
How long is your stay going to be in Lagos?
We are in Lagos till 16th of May. We started our program with 3 days of sensitization from 5th to 7th of May. And from 8th, last Thursday, to 16th of May, we are having an external court sessions. We did Thursday and Friday, where we were able to adjudicate on 11 cases. The first day, after the opening ceremony, the court had 4 cases. On Friday, we have 7 cases. So throughout, from Monday to Friday, there will be an average of 7 to 8 cases per day, and on 16th of May we will round up, and it was really productive because lawyers, they came physically, because those who usually attend the court hearing virtually, they came. Lagos lawyers, Nigerian lawyers, even outside, people came from Senegal, from Togolese Republic, and they came to adumbrate on their cases. And it's at the end of the session on Friday, we will be able to adjudicate on 52 cases within 7 days, which is unprecedented move that the court is trying to take, and it will really try to, reduce significantly the docket of cases of the Ecowas Court of Justice.
And these cases are completely free.
Yeah. They are free.
They are free.
The Ecowas Court of Justice is 100% free.
Okay, so but that means that the court is funded by the community.
The court is funded by the community. Even, the court has 3 official languages like the whole Ecowas: French, English, Portuguese. And any case that you are bringing before the court, it has to be translated.
Okay.
So even the translation is free. The court is funding for the translation. So you can see that the court is really available for
everybody.
For everybody, including the indigent.
And I'm sure that you're ready for more influx of cases now that you're sensitizing.
That's true. That's true. And I want to take this opportunity to invite all the Lagosians, the good people of Lagos, that whoever feel that is victim of violation of his human right, the court is available.
The case is open.
Yes.
And your case will be taken.
Of
All right.
course.
Thank you so much, Dr. Yahuza Urasama, for finding time to be with us on the program today. We appreciate your thoughts.
Thank you very much. Thank you.
Of course, we've been speaking with our guest who's been sensitizing us on the ECOWAS Court of Justice and how Lagos residents can also take full advantage of all that the court has to offer. And like Joy stressed it so many times during this interview, it is FOC. Free of charge. All right. If you need to also get more clarification, I'm sure you can reach out to us here. We'll guide you how to go forward on this. All right, we'll take a break. When the conversation returns, Joy and I, minus Jibola, Joy and I will be here. So we took this interview on Friday, and of course, because we could not go live during that session because of the transmission of the press briefing. So Joy and I had this next conversation on Friday. I'll be playing back to you. We'll see you again after that interview.